Justice Barrett?
I'd like to take you back, Mr. Schnapper, to Justice Sotomayor's questions about the complaint. It seems to me that the complaint in this case is materially indistinguishable from the complaint in tomorrow's case. Do you agree? Same aiding.
In which case? I'm sorry.
In tomorrow's case, in the Tomno case, the Twitter case, and this one.
Pretty much.
So they're both relying on the same aiding and abetting theory. So if you lose tomorrow, do we even have to reach the Section 230 question here? Would you concede that you would lose on that ground here?
No. So there was a motion to dismiss in tomorrow's case on JASTA grounds. It didn't get decided. So if we lose tomorrow, the defendants will be free in this case to move to dismiss. But we'd be entitled to try to amend the complaint in this case to satisfy whatever standard you establish tomorrow.
Okay, let me ask you this. I'm switching gears now. So Section 230 protects not only providers, but also users. So I'm thinking about these recommendations. Let's say I retweet an ISIS video. On your theory, am I aiding and abetting, and does the statute protect me, or does my putting the thumbs up on it create new content?
We don't read the word user in that broadly. There's not been a lot of litigation about this. We think the word user is there to deal with a situation in which one entity accesses a server, YouTube, for example, and then someone else uses that entity. Like when I go to FedEx office. FedEx office is the user that is accessing my email. And the statute protects them when I look at the FedEx computer and find the defamatory.
Let's say that I disagree with you. Let's say I'm an entity that's using the service, so I count as a user. You know, my computer is accessing the servers when I retweet the image. On your theory, could I be liable under JASTA for aiding and abetting? Without, do I lose 230 protection if I created new content?
Whether it's enough for JASTA is a separate question. The question is it outside 230?
Is it outside of 230?
And our view is the statute doesn't mean anyone who's a user who conveys third-party libel is protected. If you, let's say that you read a book and it says John Doe is a shoplifter, and you send an email that says John Doe is a shoplifter, you're using the internet. You're using the email system. But nobody thinks that Section 230 is a blanket exemption for defamation on the website as long as you're quoting somebody else. Retweeting is a very automatic way of doing it. But if you start down that road, you'd end up having to hold that any time I send a defamatory email, I'm protected as long as I'm quoting somebody else. I don't think anybody thinks
I guess I don't understand. I mean, let's see. I guess I don't understand logically why your argument wouldn't mean that I was creating new content if I retweeted or if I liked it or if I said, check this out. Why wouldn't that?
You would be, but I'm advancing an argument that gets to the same place, which is you're not a user within the meaning of the statute just because you go on email or YouTube or on
Let's
Twitter.
say I disagree with you. Let's say that I think you're a user of Twitter. If you go on Twitter and you're using Twitter and you retweet or you like or you say, check this out. On your theory, I'm not protected by Section 230.
Yeah, that's content you've created.
That's content I've created. Okay. And on the content creation point, let's imagine it seems like you're putting a whole lot of weight on the fact that these are thumbnails, and so it's something that YouTube separately creates.
Yes.
What if they just screenshot? They just screenshot the ISIS thing. They don't do the thumbnail.
Yeah,
then are
that's pure third-party content.
That's pure third. So this is just about how YouTube set it up.
That's correct in this context. And it gets back to the conversation we were having earlier about that this is a new technology that didn't exist in 1996, and rather than ask Congress to write the statute to cover it, they just went ahead and did it.
Okay, and last question. Turning to the statutory text, so it seems to me some of the briefs in this case are focusing on what it means to treat someone as a publisher, treat an entity as a publisher. You're not really focusing on that and the traditional editorial functions argument. I mean, you're really focusing on the content provider argument. correct?
No, well, we've advanced views as to each element of the claim.
But today, you've really been honing in on this. Are you actually creating content or just presenting third-party content?
Well, I've been answering, that's where the questions have
Yeah.
taken us. But our view would be that you're not being treated as a publisher of the video just because you published the thumbnail.
Okay, thank you.
You're not being harmed by the thumbnail.
Thank you.